A pleasant day to everyone. Today, we are going to discuss the Title 14 Dissolution of the Revised Corporation Code of the Philippines, Section 133 to 139.
Section 133, Methods of Dissolution. Dissolution is the extinguishment of the corporate franchise and the termination of corporate existence. Upon dissolution, a company loses its legal status and is no longer able to engage in the activities for which it was originally established. However, it will persist as a legal entity for a further 3-year duration beyond its dissolution, only to conclude its operation and distribute its asset. The law may revoke what it has granted, and a corporation may only cease operations and have its existence extinguished through the act of the state by which it was established. Dissolution can be done voluntary or involuntary. In further discussion, we will be talking about the different ways to dissolve a corporation. Section 134, Voluntary Dissolution where no creditors are affected. This section of the law states the voluntary dissolution of a corporation in which no creditors are affected. The dissolution may take effect when the requisites are followed. The resolution for the dissolution of corporation must be approved by majority vote of board of directors or trustees, majority of the outstanding capital stock or of the voting and non-voting member. Notification shall be provided to each shareholder or member of the meeting with a minimum of 20 days notice in accordance with the bylaws and as required by law with regard to the meeting's location and schedule. The purpose of the assembly should be specified as a vote on the dissolution of the corporation. A verified request for dissolution shall be filed with the Commission. The reason for the dissolution, the form, manner, and time when notice were given to the stockholders or members, the names of the stockholders and directors or members and trustees who approved the dissolution, the date, place, and time of the meeting in which the vote for the dissolution was made, the details of publication of the proposed dissolution. Furthermore, the corporation shall submit the following to the Commission: a copy of the resolution authorizing the dissolution, certified by a majority of the Board of Directors or Trustees, and countersigned by the Secretary of the Corporation. Proof of publication, favorable recommendation from the appropriate regulatory agency when necessary. Within 15 days from receipt of the verified request for dissolution and in the absence of any withdrawal within said period, the Commission shall approve the request and issue the certificate of dissolution. The dissolution shall take effect only upon the issuance by the Commission of a certificate of dissolution. The Commission will grant approval for the request for dissolution and issue the certificate of dissolution. The certificate of dissolution issued by the Commission shall indicate the date on which dissolution shall become effective. No application for dissolution of banking and quasi-banking institutions, pre-need, insurance and trust companies, non-stock savings, loan association, pawn shops, and other financial intermediaries shall be approved by the Commission unless accompanied by a favorable recommendation of the appropriate government agency. Section 135, Voluntary Dissolution where creditors are affected. Procedure and contents of petition. This section of law specifies the procedure for the voluntary dissolution of a corporation where creditors are affected. The vote required is majority vote of Board of Directors or Trustees, majority of the outstanding capital stock or of the voting and non-voting member. A verified petition for dissolution signed by a majority of the Board of Directors or Trustees, verified by the President or Secretary or one of the Directors or Trustees shall be filed with the Commission. This petition must state all claims and demands against the corporation. Dissolution was resolved upon the affirmative vote of the stockholders representing at least 2/3 of the outstanding capital stock or at least 2/3 of the member at the meeting of its stockholders or members called for that purpose. The reason for the dissolution, the form, manner, and time when the notice were given, and the date, place, and time of the meeting in which the vote was made. In addition to the petition, the corporation shall submit to the Commission the following: a copy of the resolution authorizing the dissolution, certified by the majority of the Board of Directors or Trustees, and countersigned by the Secretary of the Corporation, and a list of all its creditors. The Commission shall establish a deadline for submitting objection to the petition through an order that specifies the purpose of the petition. The deadline for objection shall not be later than 60 days from the date the order is entered, and cannot be less than 30 days after the deadline specified in order for objections to be submitted has passed. The Commission shall hear the petition and address any issue raised in the objection filed, provided that 5 days' notice has passed. The dissolution shall take effect only upon the issuance by the Commission of Certificate of Dissolution. Section 136. Dissolution by shortening corporate term. In the absence of an explicit provision to the contrary in the articles, a corporation may exist indefinitely. On the other hand, despite the perpetual existence of the corporation, the law allows for the dissolution of a corporation through voluntary dissolution and involuntary dissolution. In voluntary dissolution, there are two ways to resolve a corporation: filing an application for dissolution with the Commission, and/or by amending the articles of the incorporation to shorten the corporate term. And this article will be talking about the shortening the corporate term. In order to dissolve corporation by shortening corporate term, this procedure must be followed. A copy of the amended articles of incorporation shall be submitted to the Commission in accordance with this code. Upon the expiration of the shortened term, as stated in the approved amended articles of incorporation, the corporation shall deem dissolved without any further proceeding, subject to the provision of this code on liquidation. In the case of expiration of corporate term, dissolution shall automatically take effect on the day following the last day of the corporate term stated in the articles of incorporation, without the need for the issuance by the Commission of a certificate of dissolution. Section 137. Withdrawal of request and petition for dissolution. A verified request for dissolution is filed when no creditors are affected. Requests may be withdrawn as follows. The request for dissolution shall be made in writing, duly verified by any incorporator, director, trustee, shareholder, or member, and signed by the same number of incorporators, directors, trustees, shareholders, or members necessary to request for dissolution. The withdrawal shall be submitted no later than 15 days from receipt by the Commission of the request for dissolution. Upon receipt of a withdrawal of request for dissolution, the Commission shall withhold action on the request for dissolution and shall, after investigation, make a pronouncement that the request for dissolution is deemed withdrawn, direct a joint meeting of the Board of Directors or Trustees and the stockholders or members for the purpose of ascertaining whether to proceed with dissolution, issue such other orders as it may deem appropriate. In withdrawal of the petition for dissolution is when creditors are affected. Petition may be withdrawn by submitting a verified motion prior to the publication of the order by the Commission setting the deadline for filing objection, but within 15 days of the Commission receiving the petition for dissolution. In withdrawal of the petition for dissolution is when creditors are affected. Petition may be withdrawn by submitting a verified motion prior to the publication of the order by the Commission, setting the deadline for filing objection, but within 15 days of the Commission receiving the petition for dissolution. Upon receipt of the motion, the Commission may grant the motion, direct a joint meeting of the Board of Directors or Trustees and stockholders or members for the purpose of ascertaining whether to proceed with the dissolution, issue such other orders it may deem appropriate. Section 138. Involuntary dissolution. The corporation may dissolve in voluntary dissolution where the expiration of the corporation term ordered by the Commission and in other provision of order by the Commission and legislative enactment. This section of law is focused on the involuntary dissolution by order of the Commission. The Commission may dissolve a corporation voluntarily or in response to a verified complaint filed by an interested party. Grounds for dissolution of the corporation: non-use of corporate charter, Failure of a corporation to formally organize and commence its business within 5 years from the date of its dissolution. Continuous in the operation of a corporation. Continuous in operation for a period of 5 consecutive years after the corporation has commenced its business. Upon receipt of a lawful court order dissolving the corporation, upon finding by final judgment that the corporation procured its incorporation through fraud, was created for the purpose of committing, concealing, or aiding the commission of securities violation, smuggling, tax evasion, and more, committed or aided in the commission of illegal acts, repeatedly and knowingly tolerated the commission of graft and corruption commission. The commission after notice and hearing may dissolve a corporation upon the filing of a verified petition for its dissolution or grounds. Section 139. Corporate liquidation. Liquidation entails the gathering of the corporation's assets, the resolution of disputes with creditors and debtors, the distribution of profits and losses. It entails the asset collection, payment of all creditors, and distribution of remaining assets, and is a procedure by which the corporation's affairs wind up. Despite dissolution, the corporation shall retain its body corporate status for a period of 3 years. This is not for a purpose of conducting ongoing business, but rather to facilitate the resolution and closure of its affairs, the transfer and distribution of property, and the prosecution and defense of suits brought against it. The corporation itself may be affected by the liquidation through its board of directors or trustees, except as otherwise provided for in Section 93 and 94 of this Code. Upon the winding up of corporate affairs, any asset distributable to any creditors or stockholder or member who is unknown or cannot be found shall be escheated in favor of the national government, except by decrease of capital stock and as otherwise allowed by this code. No corporation shall distribute any of its asset or property except upon lawful dissolution and after payment of all its debts and liabilities.
Moving forward, we're also going to discuss the Title 15 Foreign Corporation of the Revised Corporation Code of the Philippines, Sections 140 to 153.
Section 140 defines foreign corporations and its strength. So this section simply means that a business license is a must for a foreign corporation to conduct business here in the Philippines because it is a legal requirement. Without this, it can maintain any action or proceedings before Philippine courts because securing a license is an assurance that it will abide by the decisions of our courts even if it adheres to it. So it has two requisites. First is that it must be formed, organized, or existing under any laws other than the Philippines. Second is that the laws of the country where the corporation was organized or originated allow Filipino citizens and corporations to do business in its own country or state. Section 141. Applications to existing foreign corporations. So the existing foreign corporations satisfy the requirements of Securities and Exchange Commission. That's why they have a license to operate here in the Philippines. So before, the life of a corporation is limited only up to 50 years and renewable again for 50 years. But the revised corporate code states that any corporation can now exist for a lifetime unless the said corporation elect to retain a specific corporate term. So every foreign corporation now, on the effectivity of this code, is authorized to do business in the Philippines under a license issued to it, shall continue to have such authority under the terms and conditions of its license, of course subject to the provisions of this code and other special laws. Section 142. This section enumerates the requirements needed for application of a license. As I've said earlier, a foreign corporation must have a business license and a certificate of authority from the Philippine Securities and Exchange Commission before conducting a business here in the Philippines. This registration is necessary to give a legal personality to a corporation. A foreign corporation applying for a license to transact business in the Philippines shall submit to the Commission a copy of its Articles of Incorporation and bylaws, certified in accordance with law, and their translation to the official language of the Philippines, which is Filipino, if necessary. The application shall be under oath and unless stated in its Article of Incorporation shall specifically set forth the following. First is the date and term of incorporation. Second is the address, including the street number of the principal office of the corporation in the country or state of the corporation. Next is the name and address of its resident agent, authorized to accept summons and process in all legal proceedings and all notices affecting the corporation, pending the establishment of a local office. Next is the place in the Philippines where the corporation intends to operate. Next is the specific purpose or purposes which the corporation intends to pursue in the transaction of its business in the Philippines, provided that the said purpose or purposes are those specifically stated in the certificate of authority issued by the appropriate government agency. Next is the names and addresses of present directors and officers of the corporation, and a statement of its authorized capital stock and aggregate number of shares which the corporation has authority to issue, and itemized by class, par value of shares, shares without par value and series, if any, and a statement of the amount actually paid in, and such additional information as may be necessary or appropriate in order to be enabled to commission to determine whether such corporation is entitled to a license to transact in the Philippines and to determine and assess the fees payable. Moving on to section 143. Issuance of a license. So after the applying foreign corporations passed all the needed documents, it will now be reviewed and validated by Securities and Exchange Commission, and if it satisfies their requirements, they will now issue in a license to operate. So upon its issuance, foreign corporation may commence to transact business in the Philippines and continue to do so for as long as it retains its authority to act as a corporation under the laws of the country or state of its incorporation, unless such license is sooner surrendered, revoked, suspended, or annulled in accordance with this code or other special laws. So this section pertains to the process of obtaining and maintaining a license for a foreign corporations to conduct business in the Philippines, with an emphasis on compliance with legal requirements and the potential consequences of non-compliance with it. If the applying corporation satisfies the requirements, it will now be issued a license by the Securities and Exchange Commission. Section 144. This section answers the question, who may be a resident agent? So a resident agent may either be an individual residing in the Philippines who must be of a good moral character and of a sound financial standing, or a domestic corporation lawfully transacting in the Philippines that may also likewise of a sound financial standing and must show proof that it is in good standing as certified by the Commission. So the purpose of appointing a resident agent is for notice affecting the corporation pending the establishment of its local office and summons and other legal processes in all proceedings for or against the corporation. Section 145. Resident Agent Service of Process. So I've mentioned previously the purposes of appointing a resident agent, and those purposes must be fulfilled by the resident agent, because the resident agent is designated by the foreign corporation who will serve as a point of contact for legal matters. In the event that there are legal actions or legal proceedings against the foreign corporation, the service of legal documents, like summons, will be directed to the resident agent. The provision emphasizes that such service upon the resident agent is considered valid and legally binding as if it were served directly on the authorized officers of the foreign corporation at its home office. In the essence, this requirement ensures that foreign corporations operating in the Philippines have a local representative or resident agent who can receive legal notices and be served with legal documents. This makes it more efficient and practical to communicate legal matters to the foreign corporations within the jurisdiction of the Philippines. It's a common practice in many jurisdictions to have designated local representatives for foreign entities to facilitate legal processes. Whenever such service of summons or other processes made upon the Commission shall mail a copy of this within 10 days to its home or principal office. The sending of such copy by the Commission shall be a necessary part of and shall be complete such service. All expenses incurred by the Commission for such service shall be paid in advance by the party at whose instance the service is made. It shall be the duty of the resident agent to immediately notify the Commission in writing of any change in the resident agent's address.
Section 146 of the Revised Corporation Code of the Philippines states that a foreign corporation that is legally conducting business in the Philippines is subject to the laws, rules, and regulations that apply to domestic corporations of the same class. This means that foreign corporations are expecting to comply with the same legal requirements as local corporations. However, there are exceptions to this rule. The laws that pertain to the creation, formation, organization, or dissolution of the corporation do not apply to the corporation, to the foreign corporation rather. These laws are specific to the jurisdiction where the corporation was originally formed. Additionally, laws that define the relationship, liabilities, responsibilities, or duties of the stockholders, members, or officers of the corporations to each other or to the corporation itself also do not apply to the foreign corporations. These aspects are typically governed by the laws of the jurisdiction where the corporation was originally formed. This provision ensures that the foreign corporations are not unduly burdened by having to comply with potentially conflicting sets of laws. It also respects the sovereignty of foreign corporations' home jurisdiction over matter of corporate governance. Section 147 of the Revised Corporation Code of the Philippines pertains to the amendments made to the Articles of Incorporation or bylaws of foreign corporation that is authorized to conduct business in the Philippines. This section ensures that the Philippine government is kept informed about any changes in the governance of foreign corporation operating in the country, while also maintaining control over the scope of the operations within its jurisdiction. First is about the amendment filing. If a foreign corporation amends its articles of incorporation or bylaws, it is required to file a copy of the amended documents with the Securities and Exchange Commission within 60 days after the amendment becomes effective. In certain cases, the documents may also need to be filed with the appropriate government agency. Second is document authentication. The copy of the amended articles of incorporations or bylaws must be authenticated and certified by the authorized officials of the country or state where the corporation was incorporated. Third is the change in indication. The changes made in the amended documents should be clearly indicated either by writing them in capital letters or by underscoring them. Fourth is the purpose of limitation. The filing of the amended document does not in itself expand or alter the purpose of the purposes for which the foreign corporation is authorized to conduct business in the Philippines. This means that even if the corporation changes purpose in its home jurisdiction, it cannot change its purpose in the Philippines without going through the legal process here in the Philippines. Section 148 of the Revised Corporation Code of the Philippines pertains to obtaining an amended license for a foreign corporation authorized to conduct business in the Philippines. This section ensures that any significant changes made by the foreign corporation, such as a change in corporate name or business purpose, are properly documented and approved by the Philippine government. This is to ensure that the foreign corporation continues to operate within the Philippine law and regulations. It also allows the government to maintain oversight over corporations operating in the country. First is about the amended license. If a foreign corporation changes its corporate name or wishes to pursue other or additional purposes in the Philippines, it must obtain an amended license. Second is application submission. The foreign corporation must submit an application for the amended license to the Securities and Exchange Commission of the Philippines. Third is endorsement. The application must be favorably endorsed by the appropriate government agency in the proper cases. This means that the relevant government agency must approve the changes before the amended license can be issued. Section 149 of the Revised Corporation Code of the Philippines pertains to the merger or consolidation involving a foreign corporation licensed in the Philippines. This section ensures that the Philippine government is kept informed about any changes in the corporate structure of a foreign corporation operating in the country, such as through merger or consolidation. It also provides a mechanism for foreign corporations to withdraw their license to operate in the Philippines in the event that they are absorbed by another corporation through a merger or consolidation. This is to ensure that the foreign corporation continues to operate within the bounds of the Philippine law and regulations. First is merger or consolidation. One or more foreign corporation authorized to transact business in the Philippines may merge or consolidate with any domestic corporation or corporations. This is permitted under the Philippine law and by the law of the Foreign Corporation Incorporation, provided that the requirements on merger or consolidation as provided in this code are followed. Second is the filing requirement. If a foreign corporation authorized to transact business in the Philippines is a party to a merger or consolidation in its home country or state, it must within 60 days after the merger or consolidation becomes effective,
file with the Securities and Exchange Commission, and in proper cases with the appropriate government agency, a copy of articles of merger or consolidation. This copy must be authenticated by proper official or officials of the country or state under whose laws and the merger or consolidation was effected. Third is withdrawal of license. If the absorbed corporation in the merger or consolidation is the foreign corporation doing business in the Philippines, it must at the same time file a petition for withdrawal of license in the accordance with this title. Section 150 of the Revised Corporation Code of the Philippines pertains to the consequences faced by a foreign corporation that is transacting business in the Philippines without a license. This section ensures that the foreign corporation cannot operate outside in the bounds of the Philippine law. If a foreign corporation chooses to conduct business in the Philippines, it must obtain the necessary license to do so. Failure to obtain a license not only restricts the corporation's legal rights, but also exposes to its potential legal actions. This provision is designed to protect the interests of the Philippine government and public and to maintain the integrity of the country's business environment. First is the prohibition on legal action. A foreign corporation that is conducting business in the Philippines without a license or its succession or assigns is not allowed to maintain or intervene in any action, suit, or proceeding in any court or administrative agency of the Philippines. This means that such a corporation cannot initiate or participate in legal proceedings in the country. Second is the liability to legal action. Despite in the above, such a corporation cannot be sued or proceeded against before Philippine court or administrative tribunals or on any valid cause of action recognized under the Philippine law. This means that while the corporation itself cannot take legal action, it can be the subject of the legal action in the Philippines. Section 151 of the Revised Corporation Code of the Philippines outlines the grounds upon which the license of a foreign corporation to transact business in the Philippines may be revoked or suspended by the Securities and Exchange Commission. This section ensures that foreign corporations comply with the laws and regulations of the Philippines. Failure to do so can result in the revocation or suspensions of their license to operate in the country. First is failure to file annual report or pay fees. If the foreign corporation fails to file its annual report or pay any fees as required by this code, its license may be revoked or suspended. Second is failure to appoint and maintain a resident agent. The license may be revoked or suspended if the foreign corporation fails to appoint and maintain a resident agent in the Philippines as required by this title. Third is the failure to submit statement of change. If the foreign corporation changes its resident agent or address and fails to submit a statement of such change to the Commission as required by this title, its license may be revoked or suspended. Fourth is failure to submit authenticated copy of the amendments. The license may be revoked or suspended if the foreign corporation fails to submit to the Commission an authenticated copy of any amendment to its articles of incorporation or bylaws or of any articles of merger or consolidation within the time prescribed by this title. Fifth is misrepresentation of material matter. If a foreign corporation misrepresents or any material matter in any application, report, affidavit, or any document submitted pursuant to this title, their license may be revoked or suspended. Sixth, failure to pay taxes, imposed assessment, or penalties. The license may be revoked or suspended if the foreign corporation fails to pay all taxes, imposed assessment, or penalties, if any, lawfully due to the Philippines government or any of the agency political subdivision. 7. Transacting business outside authorized purpose. If the foreign corporation transacts business in the Philippines outside of the purpose or the purposes for which it is authorized under its license may be revoked or suspended. 8. Transacting business on behalf of unlicensed foreign corporation. If the foreign corporation transacts business in the Philippines as an agent or acting on behalf of any foreign corporation or entity not duly licensed to do business in the Philippines, its license may be revoked or suspended. 9. And last, any other ground rendering it unfit. The license may be revoked or suspended on any other ground that would be render the foreign corporation unit to transact business in the Philippines. Section 152 of the Revised Corporation Code of the Philippines pertains to the issuance of certificate of revocation when a foreign corporation license to transact business in the Philippines is revoked. This section outlines the procedure of the Commission must follow when a foreign corporation's license to transact business in the Philippines is revoked. It ensures that all the relevant parties, including the corporation itself and other government agencies, are properly informed of the revocation. This provision is designed to maintain transparency and uphold the rule of the business environment of the Philippines. First is about the issuance of certificate of revocation. When the license of foreign corporation to transact business in the Philippines is revoked, the Securities and Exchange Commission is required to issue a corresponding certificate of revocation. Second is furnishing a copy to government agency. The Commission must furnish a copy of the certificate of revocation to the appropriate government agency in the proper cases. This ensures that relevant government bodies are informed of the revocation. Third is mailing notice to the corporation. The Commission is also required to mail a notice and a copy of the certificate of revocation to the corporation of its registered office in the Philippines. This ensures that the corporation is officially notified of the revocation of its license. Section 153 of the Revised Corporation Code of the Philippines outlines the process for a foreign corporation licensed to transact business in the Philippines to withdraw from the country. This section ensures that foreign corporation fulfills all its legal and financial obligation before it can withdraw from the Philippines. It protects the interests of the government, creditors, and other stakeholders. It also ensures transparency in the withdrawal process. First is filing a petition. A foreign corporation may be allowed to withdraw from the Philippines by filing a petition for withdrawal of license. This is subject to existing laws and regulations. Second is issuance of certificate of withdrawal. The Securities and Exchange Commission will not issue a certificate of withdrawal unless all of the following requirements are met. First is settlement of claims. All claims which have accrued in the Philippines must have been paid, compromised, or settled. This means that the corporation must settle all its outstanding financial obligation in the country. Second is payment of taxes and penalties. All taxes, imposed, assessment, and penalties, if any, lawfully due to the Philippine government or any of its agency or political subdivision must have been paid. This ensures that the corporation has fulfilled all its tax obligation before leaving the country. Third and last is the publication of petition. The petition for withdrawal of license must have been published once a week for 3 consecutive weeks in a newspaper or general circulation in the Philippines. This is to inform the public and any potential creditors of the corporation's intentions to withdraw from the country.
And that's all for our video about the Title 14 and Title 15 of the Revised Corporation Code. Thank you for watching.